Welcome back, everybody, to the On The Docket Podcast. For this sixth episode, we're going to be looking at a case that involves the relationship between the United States government and the various native tribes indigenous to the land. We're going to be looking at what powers each has in enforcing their respective codes and laws. Today, we're going to be looking at the 1978 Supreme Court case, United States v. Wheeler. In 1974, a man named Anthony Robert Wheeler, who belonged to the Navajo tribe, was charged with disorderly conduct. He later pleaded guilty to that, as well as contributing to the delinquency of a minor. His charges and pleas were made within the confines of the Navajo tribal court system. In 1975, however, the federal government brought charges against Wheeler after a grand jury indicted him for rape, which occurred at the same incident that resulted in his charges through the Navajo tribe. Wheeler's attempt to quash the indictment on the ground that his Fifth Amendment right against double jeopardy was being violated proved successful in the district court. On appeal, the Court of Appeals for the Ninth Circuit affirmed the decision of the lower court, and the United States appealed to the U.S. Supreme Court. I would like to turn now to the oral arguments, but before I do so, I just want to make sure everybody understands what is at issue here, just in case someone isn't familiar with the Fifth Amendment. Most people recognize the Fifth Amendment as being the amendment that contains your Miranda rights, made infamous by the landmark case Miranda v. Arizona. However, the Fifth Amendment protects citizens from self-incrimination, establishes eminent domain, and protects citizens from double jeopardy. Double jeopardy is being tried for the same crime twice, despite the fact that the first trial had already come to a conclusion. What this means is, if I'm a person found guilty of robbing a bank and serving prison time for that, once I get released from prison, I can't be retried for that same crime because I already did the time. This also applies even if a person is found not guilty and doesn't suffer a punishment. This does not apply to things like a mistrial where a whole new trial needs to be conducted because there is some grievous error with the first. Double jeopardy is the focal point of the issue here because Anthony Wheeler was tried and punished by the Navajo Tribal Court. He is arguing that by bringing the rape charges against him, the federal government is trying and punishing him for a crime that he is already punished for. With that being said, let's turn to the oral arguments and see how the government responds. The United States principal argument in this case was put forth when the Counsel for the United States said, quote, "Tribes are not independent from the federal government, and there is only two sovereigns in this country in this true sense of that term. That is, the United States and the states. As I will explain, however, the concept of residual sovereignty is historically and analytically a correct way to understand the retained power of the tribes. And on the basis of this concept, together with the undesirable consequences that would follow if the Court of Appeals' holding were affirmed in this case, we contend that the doctrinal and the policy justifications that underlie the dual sovereignty principle apply in a tribal context, even though the tribes are not states," unquote. So essentially what the United States is saying here, and a theme that they will continue to talk about throughout their argument, is the fact that tribal courts are independent enough from the federal government such that the principle of dual sovereignty applies to them, but they are not an entirely separate sovereign in the same way that states are. Before the United States was the United States as we know it, indigenous tribes settled the land. Just like any other settlement of people, they created codes of morals that its members had to live by, and they also created institutions to deal with members who broke those codes. In other words, indigenous tribes had their own court system long before the establishment of the federal government. Thus, when they were forcefully and violently removed from their settlements, the federal governments looked at what few tribe members remained and recognized their court systems and accepted that these court systems can continue to exist alongside the federal government in a capacity that was defined by legislation such as the Major Crimes Act of 1885. Wheeler's argument, however, is that tribal courts are wholly and inseparably an arm of the federal government, that they were established by the federal government, and that his convictions in both tribal and federal courts for crimes deriving from the same incident thus violate his Fifth Amendment right against double jeopardy. I just want to hammer home this point with another quote from the Counsel for the United States, which is, quote, "It is our point here, and I think this is really consistent with the entire course of judicial decision of this area, is that tribal courts are not creations of the federal government in that sense. And so I would submit to you that there does not exist a federal statute which creates the tribal courts or gives them jurisdiction, although there may well be statutes and treaties which recognize the tribes have this power," unquote. So again, the fact that the federal government recognizes tribal court authority does not mean that tribal courts are wholly established by the federal government. Instead, the government is putting forth the argument that it merely recognizes the coexistent jurisdiction that tribal courts have alongside federal courts. Those two excerpts were the most interesting moments in the petitioner's oral arguments, but there were some moments in the respondent's oral arguments that I think deserve some attention. Things got off to a shaky start when Wheeler's lawyer gets into a bit of a back and forth with Chief Justice Berger. Wheeler's counsel says, quote, "The pervasive federal influence to control over all the aspects of the tribal right is strikingly evidenced by the fact that the crime scene was in the compound of a high school run by a federal agency, the Bureau of Indian Affairs." To which Justice Berger responds, quote, "Would that have much to do with jurisdiction?" unquote. O'Toole responds with, quote, "Well, Your Honor, this is merely an example of the pervasive control of the federal government over all aspects of tribal life." To which Justice Berger responds, "I agree, it is historically true that there has been pervasive control in many aspects, but it does not really go to the heart of jurisdiction, does it?" O'Toole comes back with, "Well, I submit, Your Honor, that the key to this case is whether Indian tribes are sovereign like states in the federal government." And then he's interrupted by Justice Berger, who says, "They're not sovereign like the federal government or like states." To which O'Toole argues, "Well, as this court has long recognized, the dual sovereignty exception never has been applied out of a context of successive state and federal prosecutions. In fact, it has not been extended to the territories of the United States, which this court has recognized very recently as being exercising powers of self-government, similar to Indian tribes, and in fact exercising these powers with independence much greater than the Indian tribes." To which Justice Berger says, "It does not have any residual sovereignty, does it? The territory has no residual sovereignty." And O'Toole responds, "That is correct. It emanates from a grant of power from the Constitution." Then Justice Rehnquist says, "In what case did we recognize the territories had powers just like Indian tribes?" In response to this, counsel brings up Puerto Rico v. Shell Company, and there's some more debate over whether the precedents set in this case and others truly apply to the case at hand. This whole thing goes on for quite a while and without any really satisfactory conclusion, but I just wanted to talk about it to show that Wheeler started his oral arguments on very shaky footing. There appears to be a disconnect in the understanding of precedent cases between Wheeler's counsel and the justices. Wheeler's argument is basically that tribal courts are a part of the federal court system because they were created when the federal government recognized them. This is opposed to the United States argument, which is that the federal government simply recognized the jurisdiction that tribal courts had because they predated the federal government itself, but it does not create authority in the tribal courts. Eventually, they get into the real nitty-gritty over what sovereignty looks like judicially. That is, if an entity is to be considered sovereign, it needs to have the ability to enforce laws, by putting someone in jail, for example. If a Navajo tribe can find a defendant guilty and put them in jail, they would then have sovereignty. This is at the heart of the issue when Justice Thurgood Marshall says, "If you want to put a person in jail, you need sovereignty." O'Toole responds, "Well, Your Honor, certainly local and state governments have the power to put people in jail, but I think the course of the power is the key that this court has to examine to determine, first of all, whether they have even residual sovereignty, let alone sovereignty." To which Justice Marshall says, "And you said it is there. Now, where does the Navajo tribe get that power?" To which Justice O'Toole responds, "Well, without quoting it, Your Honor indicates that the Department of the Interior to the Director of the Bureau of Indian Affairs has the power to control tribal courts, law and order, police, judges, and so forth, and necessarily, I submit, the regulations in 25 CFR which exist." To which Justice Marshall responds, "You mean that the federal government sits on each one of these cases? The answer is no." Justice O'Toole says, "No, Your Honor, they do not. The judges of the tribe sit on these cases over tribal matters, but I submit that this sitting on cases is because the power has been granted to the tribes by the federal government, not because of any existing and unrecognized," at which point he's interrupted by Justice Marshall, who asks, "Now, who tried them before 200 years ago?" Justice O'Toole says, "The members of the tribe, Your Honor." To which Justice Marshall says, "So it did not come from Congress." So as you can see, Justice Marshall made his opinion fairly clear. Wheeler's point is that had Congress not granted Navajo courts any jurisdiction, the Navajo courts would have no ability to try its members for crimes committed within its community. Marshall is not convinced, instead arguing that indigenous tribes have a sort of residual sovereignty and a residual ability to try criminals that survived the conquest of settlers who were pushing west at the expense of those tribes. Those were the most interesting moments from the oral arguments that I wanted to bring up. Now let's get into the opinion. This Berger Court decision was unanimously in favor of the United States. Justice Potter Stewart delivered the opinion of the court, which reads as follows. The question presented in this case is whether the double jeopardy clause of the Fifth Amendment bars the prosecution of an Indian in a federal district court under the Major Crimes Act when he has been previously convicted in a tribal court of a lesser included offense arising out of the same incident. On October 16, 1974, the respondent, a member of the Navajo tribe, was arrested by a tribal police officer at the Bureau of Indian Affairs High School in Many Farms, Arizona, on the Navajo Indian Reservation. He was taken to a tribal jail in Chinle, Arizona, and charged with disorderly conduct in violation of Title 17, Section 351 of the Navajo Tribal Code. On October 18th, 2 days after his arrest, the respondent pleaded guilty to disorderly conduct and a further charge of contributing to the delinquency of a minor in violation of Title 17, Section 321 of the Navajo Tribal Code. He was sentenced to 15 days in jail or a fine of $30 on the first charge and to 60 days in jail to be served concurrently with the other jail term or a fine of $120 on the second. Over a year later, on November 19, 1975, an indictment charging the respondent with statutory rape was returned by a grand jury in the United States District Court for the District of Arizona. The respondent moved to dismiss the indictment, claiming that since the tribal offense of contributing to the delinquency of a minor was a lesser-included offense of statutory rape, the proceedings that had taken place in the tribal court barred a subsequent federal prosecution. The district court, rejecting the prosecutor's argument that, quote, there is not an identity of sovereignties between the Navajo tribal courts and the courts of the United States, unquote, dismissed the indictment. The Court of Appeals for the Ninth Circuit affirmed the judgment of dismissal, concluding that since, quote, Indian trial courts and United States district courts are not arms of separate sovereigns, unquote, the double jeopardy clause barred the respondent's trial. We granted certiorari to resolve an inter-circuit conflict. In Bartkus v. Illinois and Abati v. United States, this court reaffirmed the well-established principle that a federal prosecution does not bar a subsequent state prosecution of the same person for the same acts, and a state prosecution does not bar a federal one. The basis for this doctrine is that prosecutions under the laws of separate sovereigns do not, in the language of the Fifth Amendment, quote, subject the defendant for the same offense to be twice put in jeopardy, unquote. An offense in its legal signification means the transgression of a law. Every citizen of the United States is also a citizen of a state or a territory. He may be said to owe allegiance to two sovereigns and may be liable to punishment for an infraction of the laws of either. The same act may be an offense or transgression of the laws of both. That either or both may, if they see fit, punish such an offender cannot be doubted. Yet it cannot be truly averred that the offender has been twice punished for the same offense, but only that by one act he has committed two offenses, for each of which he is justly punishable. It was noted in Abati that the undesirable consequences that would result from the imposition of a double jeopardy bar in such circumstances further support the dual sovereignty concept. Prosecution by one sovereign for a relatively minor offense might bar prosecution by the other for a much graver one, thus effectively depriving the latter of the right to enforce its own laws. While the court said conflict might be eliminated by making federal jurisdiction exclusive where it exists, such a marked change in the distribution of power to administer criminal justice would not be desirable. The dual sovereignty concept does not apply, however, in every instance where successive cases are brought by nominally different prosecuting entities. Grafton v. United States held that a soldier who had been acquitted of murder by a federal court-martial could not be retried for the same offense by a territorial court in the Philippines. And Puerto Rico v. Shell Company reiterated that successive prosecutions by federal and territorial courts are impermissible, because such courts are creations emanating from the same sovereignty. Similarly, in Waller v. Florida, we held that a city and the state of which it is a political subdivision could not bring successive prosecutions for unlawful conduct growing out of the same episode, despite the fact that state law treated the two as separate sovereignties. The respondent contends, and the Court of Appeals held, that the dual sovereignty concept should not apply to successive prosecutions by an Indian tribal court and the United States, because the Indian tribes are not themselves sovereigns but derive their power to punish crimes from the federal government. This argument relies on the undisputed fact that Congress has plenary authority to legislate for the Indian tribes in all matters, including their form of government. Because of this all-encompassing federal power, the respondent argues that the tribes are merely arms of the federal government, which, in the words of his brief, quote, owe their existence and vitality solely to the political department of the federal government, unquote. We think that the respondent and the Court of Appeals, in relying on federal control over Indian tribes, have misconceived the distinction between those cases in which the dual sovereignty concept is applicable and those in which it is not. It is true that territories are subject to the ultimate control of Congress, and cities to the control of the state which created them, but that fact is not relied upon as the basis for the decisions in Grafton, Shell, and Waller. What differentiated those cases from Bartkus and Abati was not the extent of control exercised by one prosecuting authority over the other, but rather the ultimate source of the power under which the respective prosecutions were undertaken. Bartkus and Abati rest on the basic structure of our federal system, in which states and the national government are separate political communities. State and federal governments, quote, derive power from different sources, unquote, each from the organic law that established it. Each has the power inherent in any sovereign independently to determine what shall be an offense against its authority and to punish such offenses, and in doing so, each is exercising its own sovereignty, not that of the other. And while the states as well as the federal government are subject to the overriding requirements of the federal constitution, and the Supremacy Clause gives Congress within its sphere the power to enact laws superseding conflicting laws of the states, this degree of federal control over the exercise of state governmental power does not detract from the fact that it is a state's own sovereignty which is the origin of its power. By contrast, cities are not sovereign entities. Rather, they have been traditionally regarded as subordinate governmental instrumentalities created by the state to assist in carrying out of state governmental functions. A city is nothing more than an agency of the state. Any power it has to define and punish crimes exists only because such power has been granted by the state. The power derives from the source of its creation. As we said in Waller v. Florida, the judicial power to try petitioner in municipal court springs from the same organic law that created the state court of general jurisdiction. Similarly, a territorial government is entirely the creation of Congress, and its judicial tribunals exert all of the powers by authority of the United States. When a territorial government enacts and enforces criminal laws to govern its inhabitants, it is not acting as an independent political community like a state, but as an agency of the federal government. Thus, in a federal territory and the nation, as in city and a state, there is but one system of government or of laws operating within its limits. City and state, or territory and nation, are not two separate sovereigns to whom the citizen owes separate allegiance in any meaningful sense, but one alone. And the dual sovereignty concept of Bartkus and Abati does not permit a single sovereign to impose multiple punishment for a single offense merely by the expedient of establishing multiple political subdivisions with the power to punish crimes. It is undisputed that Indian tribes have power to enforce their criminal laws against tribe members. Although physically within the territory of the United States and subject to ultimate federal control, they nonetheless remain a separate people, with the power of regulating their internal and social relations. Their right of internal self-government includes the right to prescribe laws applicable to tribe members and to enforce those laws by criminal sanctions. As discussed above, the controlling question in this case is the source of this power to punish tribal offenders. Is it part of inherent tribal sovereignty or an aspect of the sovereignty of the federal government which has been delegated to the tribes by Congress? The powers of Indian tribes are, in general, quote, inherent powers of a limited sovereignty which has never been extinguished, unquote. Before the coming of the Europeans, the tribes were self-governing, sovereign political communities. Like all sovereign bodies, they then had the inherent power to prescribe laws for their members and to punish infractions of those laws. Indian tribes are, of course, no longer possessed of the full attributes of sovereignty. Their incorporation within the territory of the United States and their acceptance of its protection necessarily divested them of some aspects of the sovereignty which they had previously exercised. By specific treaty provision, they yielded up other sovereign powers. By statute, in the exercise of its plenary control, Congress has removed still others. But our cases recognize that the Indian tribes have not given up their full sovereignty. We have recently said Indian tribes are unique aggregations possessing attributes of sovereignty over both their members and their territory. They are a good deal more than private voluntary organizations. The sovereignty that the Indian tribes retain is of a unique and limited character. It exists only at the sufferance of Congress and is subject to complete defeasance. But until Congress acts, the tribes retain their existing sovereign powers. In sum, Indian tribes still possess those aspects of sovereignty not withdrawn by treaty or statute, or by implication as a necessary result of their independent status. It is evident that the sovereign power to punish tribal offenders has never been given up by the Navajo tribe, and that tribal exercise of that power today is therefore the continued exercise of retained tribal sovereignty. Although both of the treaties executed by the tribe with the United States provided for punishment by the United States of Navajos who commit crimes against non-Indians, nothing in either of them deprived the tribe of its own jurisdiction to charge, try, and punish members of the tribe for violations of tribal laws. On the contrary, we have said that implicit in these treaty terms was the understanding that the internal affairs of the Indians remained exclusively within the jurisdiction of whatever tribal government existed. Similarly, statutes establishing federal criminal jurisdiction over crimes involving Indians have recognized an Indian tribe's jurisdiction over its members. The first Indian Trade and Intercourse Act provided only that the federal government would punish offenses committed against Indians by any citizen or inhabitant of the United States. It did not mention crimes committed by Indians. In 1817, federal criminal jurisdiction was extended to crimes committed within the Indian country by any Indian or other person or persons. But any offense committed by one Indian against another within any Indian boundary was excluded. In the Indian Trade and Intercourse Act of 1834, Congress enacted the direct progenitor of the General Crimes Act, which makes federal enclave criminal law generally applicable to the crimes in Indian country. In this statute, Congress carried forward the intra-Indian offenses exception because the tribes have exclusive jurisdiction of such offenses, and we cannot, with any justice or propriety, extend our laws to them. And in 1854, Congress expressly recognized the jurisdiction of tribal courts when it added another exception to the General Crimes Act, providing that the federal courts would not try an Indian who has been punished by the local law of the tribe. Thus, far from depriving Indian tribes of their sovereign power to punish offenses against tribal law by members of a tribe, Congress has repeatedly recognized the power and declined to disturb it. Moreover, the sovereign power of a tribe to prosecute its members for tribal offenses clearly does not fall within that part of sovereignty which the Indians implicitly lost by virtue of their dependent status. The areas in which such implicit divestiture of sovereignty has been held to have occurred are those involving the relations between an Indian tribe and non-members of the tribe. Thus, Indian tribes can no longer freely alienate to non-Indians the land they occupy. They cannot enter into direct commercial or governmental relations with foreign nations, and as we have recently held, they cannot try non-members in tribal courts. These limitations rest on the fact that the dependent status of Indian tribes within our territorial jurisdiction is necessarily inconsistent with their freedom independently to determine their external relations. But the powers of self-government, including the power to prescribe and enforce internal criminal laws, are of a different type. They involve only the relations among members of the tribe. Thus, they are not such powers as would necessarily be lost by virtue of a tribe's dependent status. The settled doctrine of the law of nations is that a weaker power does not surrender its independence, its right to self-government, by associating with a stronger and taking its protection. That the Navajo tribe's power to punish offenses against tribal law committed by its members is an aspect of its retained sovereignty is further supported by the absence of any federal grant of such power. If Navajo self-government was merely the exercise of delegated federal sovereignty, such a delegation should logically appear somewhere, but no provision in the relevant treaties or statutes confers the right of self-government in general or the power to punish crimes in particular upon the tribe. It is true that in the exercise of the powers of self-government, as in all other matters, the Navajo tribe, like all Indian tribes, remains subject to ultimate federal control. Thus, before the Navajo Tribal Council created the present tribal code and tribal courts, the Bureau of Indian Affairs established a Code of Indian Tribal Offenses and a Court of Indian Offenses for the reservation. Pursuant to federal regulations, the present tribal code was approved by the Secretary of the Interior before becoming effective. Moreover, the Indian Reorganization Act of 1934 and the Act of April 19, 1950 each authorized the tribe to adopt a constitution for self-government. And the Indian Civil Rights Act of 1968 made most of the provisions of the Bill of Rights applicable to the Indian tribes and limited the punishment tribal courts could impose to imprisonment for 6 months or a fine of $500 or both. But none of these laws created the Indians' power to govern themselves and their right to punish crimes committed by tribal offenders. Indeed, the Wheeler-Howard Act and the Navajo-Hopi Rehabilitation Act both recognized that Indian tribes already had such power under existing law. That Congress has, in certain ways, regulated the manner and the extent of the tribal power of self-government does not mean that Congress is the source of that power. In sum, the power to punish offenses against tribal law committed by tribe members, which was part of the Navajo's primeval sovereignty, has never been taken away from them, either explicitly or implicitly, and is attributable in no way to any delegation of them of federal authority. It follows that when the Navajo tribe exercises this power, it does so as part of its retained sovereignty and not as an arm of the federal government. The conclusion that an Indian tribe's power to punish tribal offenders is part of its own retained sovereignty is clearly reflected in a case decided by this court more than 80 years ago, Talton v. Mays. There, a Cherokee Indian charged with murdering another Cherokee in the Indian Territory claimed that his indictment by the tribe was defective under the grand jury clause of the Fifth Amendment. In holding that the Fifth Amendment did not apply to tribal prosecutions, the court stated, quote, "The case depends on whether the powers of local government exercised by the Cherokee Nation are federal powers created by and springing from the Constitution of the United States, and hence controlled by the Fifth Amendment of the Constitution, or whether they are local powers not created by the Constitution, although subject to its general provisions and the paramount authority of Congress." The repeated adjudications of this court have long since answered the former question in the negative. True it is that in many adjudications of the court, the fact has been fully recognized that although possessed of these attributes of local self-government, when exercising their tribal functions, all such rights are subject to the supreme legislative authority of the United States. But the existence of the right in Congress to regulate the manner in which the local powers of the Cherokee Nation shall be exercised does not render such local powers federal powers arising from and created by the Constitution of the United States. The relevance of Talton v. Mays to the present case is clear. The court there held that when an Indian tribe criminally punishes a tribe member for violating the tribe law, the tribe acts as an independent sovereign and not as an arm of the federal government. Since tribal and federal prosecutions are brought by separate sovereigns, they are not for the same offense, and the double jeopardy clause thus does not bar one when the other has occurred. The respondent contends that, despite the fact that successive tribal and federal prosecutions are not for the same offense, the dual sovereignty concept should be limited to successive state and federal prosecutions. But we cannot accept so restrictive a view of that concept, a view which, as has been noted, would require disregard of the very words of the double jeopardy clause. Moreover, the same sort of undesirable consequences identified in Abati could occur if successive tribal and federal prosecutions were barred, despite the fact that tribal and federal courts are arms of separate sovereigns. Tribal courts can impose no punishment in excess of 6 months imprisonment or a $500 fine. On the other hand, federal jurisdiction over crimes committed by Indian includes many major offenses. Thus, when both a federal prosecution for a major crime and a tribal prosecution for a lesser included offense are possible, the defendant will often face the potential of a mild tribal punishment and a federal punishment of substantial severity. Indeed, the respondent in the present case faced the possibility of a federal sentence of 15 years in prison, but received a tribal sentence of no more than 75 days and a small fine. In such a case, the prospect of avoiding more severe federal punishment would surely motivate a member of a tribe charged with the commission of an offense to seek to stand trial first in a tribal court. Were the tribal prosecution held to bar the federal one, important federal interests in the prosecution of major offenses on Indian reservations would be frustrated. This problem would of course be solved if Congress, in the exercise of its plenary power over the tribes, chose to deprive them of criminal jurisdiction altogether. But such a fundamental abridgment of the powers of Indian tribes might be thought as undesirable as the federal preemption of state criminal jurisdiction that would have avoided conflict in Bartkus and Abati. The Indian tribes are distinct political communities with their own mores and laws, which can be enforced by formal criminal proceedings in tribal courts as well as by less formal means. They have a significant interest in maintaining orderly relations among their members and in preserving tribal customs and traditions, apart from the federal interest in law and order on the reservation. Tribal laws and procedures are often influenced by tribal custom and can differ greatly from our own. Thus, tribal courts are important mechanisms for protecting significant tribal interests. Federal preemption of a tribe's jurisdiction to punish its members for infraction of tribal law would detract substantially from tribal self-government, just as federal preemption of state criminal jurisdictions would trench upon important state interests. Thus, just as in Bartkus and Abati, there are persuasive reasons to reject the respondents' arguments that we should arbitrarily ignore the settled dual sovereignty concept as it applies to successive tribal and federal prosecutions. Accordingly, the judgment of the Court of Appeals is reversed and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Mr. Justice Brennan took no part in the consideration or decision of this case. So that was the unanimous opinion of the court. Now let's break it down to get a better sense of what the justices were saying. The court ultimately rules that the Fifth Amendment Double Jeopardy Clause does not prevent Anthony Wheeler from being tried in both tribal and federal court for offenses stemming from the same incident. He can be tried by both tribal and federal court. The justices arrive at this opinion by first answering the question of whether or not tribal courts are separate sovereigns. They rule that tribal courts are separate from federal sovereigns. They are not arms of the federal government. Perhaps the most dispositive precedent cases that were used to come to this conclusion were Talton v. Mays and Abati v. United States. In Talton, the court ruled that when a tribal court punishes a member of its community for violating the laws established by the tribe, it is acting as an independent sovereign, separate from the federal government. Here we have a situation that is near identical to Talton. In Abati, the court held that a defendant can be tried in state court and federal court for the same crime, and that does not violate the double jeopardy clause. The court justified its decision in Abati with its desire to avoid so-called undesirable consequences, which you probably heard sprinkled throughout this opinion. The undesirable consequences that the court wanted to avoid was that if state courts and federal courts were held to be the same sovereign, meaning that a conviction in one would prevent a conviction in another court, there would be situations where defendants would commit multiple crimes, potentially tried for a lesser crime in the state court, and then would not be held accountable for the greater crime in federal court, or vice versa. For example, imagine a burglar breaking into a home to steal. While the burglar is stealing jewelry and electronics, the homeowners confront the burglar and the burglar kills the homeowner. The undesirable consequence in this scenario would be that the state court tries and convicts the burglar for breaking and entering, but consequently prevents them from being convicted for the murder of the homeowners in federal court. In order to avoid this conundrum, the Supreme Court held that state courts and federal courts were separate sovereigns, so conviction in one does not prohibit a conviction in the other. The court uses that logic and applies it to this case. The undesirable consequence in this situation would be that Wheeler gets convicted in a tribal court of disorderly conduct, which would consequently bar him from getting tried for rape in federal court. The court avoids this by holding that tribal courts and federal courts are separate sovereigns, similarly to how state and federal courts are separate sovereigns. The court also recognizes the residual sovereignty of indigenous tribes and their courts. They articulate that the treaties and laws that the federal government has made pertaining to those tribes does not grant them any powers as it might with a territory or state. Rather, it recognizes the retained powers that tribes kept as their land was taken from them. In oral arguments, the defense tried to argue that the power of tribes is similar in nature to the powers allocated to territories, states, and cities. The court disagrees with this perspective, mainly because territories and states are created by Congress, so all the power vested in them is vested in them by Congress. This is not the case with indigenous tribes. Like I said before, they have retained some amount of power over the years. The defense also tried to bring up that Congress has near ultimate authority over tribes, therefore they should be considered creations of Congress. The court, however, denies this argument as well. Even though it is true that Congress has absolute power over the tribes by controlling their funding as well as through other means, the court finds that there is no legislation, no treaties, or anything else that suggests that Congress gave indigenous people the power to govern themselves. In fact, to the contrary, the court cites numerous pieces of legislation in which Congress refuses to interfere with the jurisprudence of tribal courts, specifically because of their retained right to self-government. So that was the opinion of the court. As for Wheeler, I was unable to find a lot of reliable sources detailing what happened to him. One source says that he's still alive and a registered sex offender. Another source says that he's still alive and working as a water and sewer contractor, but doesn't specify whether or not he's on the sex offender registry. And another says that he was shot and killed by members of the SWAT team after an armed standoff with police in 2010. Regardless, the criminal jurisdiction of indigenous courts is still somewhat murky territory. There are a lot of questions that have yet to be answered, but this case was one of many that attempts to robustly define criminal jurisdiction on indigenous land. Anyways, that's the end of this episode of the On The Docket podcast. I hope you enjoyed it, and if you did, please consider hitting the like button, pressing subscribe, and sharing with someone who you think would find this interesting. I'm not going to say too much about the next episode other than that it's a fairly recent case and that it's a return to the 8th Amendment. Thank you so much for listening, and I'll see you on the next one. Bye.